We are often consulted by employees whose employment has been terminated in circumstances that they consider to be unfair. While employees are usually looking for compensation, quite often they're also looking to challenge an injustice and to correct the record. The bad news for employees is that Hong Kong labour laws don't recognise or really even care for fairness in the case of most terminations. An employer, and for that matter an employee, can terminate the employment relationship capriciously and without cause, provided however that the contractual and statutory payments are made, which are usually pretty limited. In such circumstances, the employee would not have recourse against the employer. This can leave employees feeling helpless, frustrated and unheard, and without a forum to ventilate their perceived injustice. There have been efforts to try and expand the law to close the unfairness gap. Most recently this was considered at length in the judgment of Haveaux versus Kong Express Airways. Haveaux involved a pilot whose employment was terminated by the airline with a payment in lieu of notice, but in circumstances where the airline considered that the pilot acted improperly, this was disputed by the pilot. The facts of the case are very detailed and technical, but as a general concept, the pilot tried to argue that the airline breached the implied duty of trust and confidence when terminating his employment. Specifically, the pilot claimed that the airline abused its powers and terminated his employment in bad faith that led to substantial loss. It is important to note that in this case, the pilot was not summarily dismissed for cause. He was terminated with a payment in lieu of notice. At its core, the airline's defence was very simple. It said that it had a statutory and contractual right to terminate the pilot's employment for a good, bad, or no reason at all, provided it made the payment in lieu of notice, which it did. It argued that the law does not imply a term into a contract that means it has to have a good case or give an opportunity for the employee to reply. In reaching its decision in Haveaux, the court had to consider the case of Sunny Tadjudin versus Bank of America. This is a case that has come up frequently during the past decade and concerns the Hong Kong Court of Appeal's decision to uphold a former banker's argument that her employment contract included an implied term of anti-avoidance. This, in essence, meant that her employer could not terminate her employment to deprive her from receiving the annual bonus. It was suggested that as a result of the decision in Sunny, there might be other possibilities of the court finding in favour of dismissed employees, such that the employer does not have an absolute right to terminate. Unfortunately for employees across Hong Kong, the court quickly shot down any suggestion that the implied term of trust and confidence could be expanded to offer protection against termination. With reference to Sunny, while lawyers have attempted to argue that the implied anti-avoidance term is now part of Hong Kong law, the decision in Haveaux has confirmed that it was limited to the facts in Sunny. It does not mean that it won't be applicable in other circumstances, but those circumstances would have to meet the strict rules for implying such a term. Moreover, anti-avoidance only restricted the employer's ability to terminate to avoid making a bonus payment. It does not restrict the employer's general right to terminate an employee on notice. This is a statutory right that is granted by Section 6 of the Employment Ordinance, and the right to make a payment in lieu is granted by Section 7. The law does not allow for an implied term to trump an express term, whether that term is statutory or contractual. The court also considered that it would be judicial overreach to expand the common law in this way to grant additional protection against termination. This is a matter for legislation. The Hong Kong position is very different from the UK. In the UK, the Employment Rights Act 1996 provides a very comprehensive statutory regime for employment protection against unfair dismissal, whereas the Hong Kong Employment Ordinance is much more limited in scope and application. There are still limited protections in Hong Kong. For example, an employment relationship cannot be terminated in cases where it is contrary to anti-discrimination legislation. Also, the unfettered right to terminate for good, bad or no reason only applies for terminations with notice or payment in lieu. In the case of a summary termination for cause, the employee will always have the right to challenge the employer for wrongful termination. This would, at the very least, require the employer to justify their decision and give the employee their much-desired day in court.